Hello, this video is going to be talking about the exclusive right to sell property listing agreement updated in September of 2024. As every document, please check with your broker to see if there's additional documents that you need. Check with your broker to see if your company has different documents in different forms. And one class, one video doesn't make an expert. You need to continue, you need to research, you need to study, you need to practice. So let me encourage you to do those things with the exclusive right to sell listing agreement. So what we're going to talk about, again, people can read. I'm going to try and put this in a way that you can explain it to them. Notice right up there at the front part, at the top, it says this is a legally binding contract. One thing people forget is any type of agreement, if it is signed by two parties, becomes a contract. Same thing here. You have an agreement between the listing licensee and the seller. There's going to be a bilateral agreement, meaning two parties involved, two parties getting benefit. So it is a legally binding document. If you have any questions, make sure you tell them to consult an attorney. We is going to be the owners, and do your due diligence. Make sure that the people that have called you and that are going to sign have the authority and the right to sell the property. Check your tax records. If you can, have the deed pulled. Look on the probate website and see who owns the property. There have been instances not too long ago where somebody was selling a home and they were selling their grandmother's home, but they did not have the authority. Grandmother was down in Florida enjoying retirement and grandson was trying to sell the house. So make sure you do your due diligence, you research, and you make sure that the people that have called you and the people that are going to sign have the authority to sell. We're going to write the street address, city, county, state, zip code, the legal description. You pull the tax record, you put the lot and the block and the subdivision. If it is out in the county, if it's not platted in a subdivision, then it's going to be meet and bounds. This is what the seller is going to give to the broker: the authority and permission to send the property information, internet, to print information about the property, to place a lockbox on the property, and in doing so it holds the company hold harmless on that. To publish in the MLS information about the property, everything that is pertinent to the house. So those are the things that the seller allows the listing agent to do. You can have all this information, you can read it to them, but basically it says that there can't be any fault taken by the information. The seller is going to look at it, validate it, make sure it's as accurate as it can possibly be, and then it's going to go out. Period of agreement. It has to have a start date and has to have an ending date. Cannot automatically renew. Also notice, here is where the price that you're going to market the property. There's the price and the possession date. Possession date, as on the sales contract, should be at closing. If there is a different date other than at closing, check with your broker to make sure how you handle that. Disclosure. It says seller hereby authorizes broker and all cooperating brokers to disclose to prospective buyers, to the extent required by law, any defects latent or otherwise known to them. Sellers acknowledge that the licensees do not have the responsibility of discovering latent defects in the property or to advise on matters outside the scope of their license. So in other words, it's not your job as the listing agent to go and discover if the property has mold or if it has an issue. Now, if you know that it has an issue, you need to disclose it. You cannot hide it, especially if it's health and safety. So again, you as the listing agent do not have the obligation to go and do a property inspection and say, well, your panel box is double tapped or anything like that. You need to just stick to the real estate aspect of it. Marketing the property. These are just some of the different ways that we're going to market the property into the MLS. This says that as soon as you get it, you're going to enter it into the MLS within 1 business day of marketing to the public. So if you put a sign out in the yard 1 day, and you need to have it in the MLS. If you printed flyers, if you put it on social media, 1 day, put it in the MLS. There is a fine if you do not. They do audit every so often. It says broker agrees to use reasonable effort in marketing the property in accordance to this agreement. Again, the seller gets benefits because you're not going to sell the house. It is your job as the listing agent to market the house, and you're going to use all your skills and all the company's abilities to disseminate this information and market the property to find a buyer. You're going to be, unless the seller says no sign, you're going to put a sign. You're going to get this information out to as much of the public as you can. Also, notice it talks about promptly refer all inquiries regarding property to the broker. So if the seller has information, somebody says, I'm interested in buying, they have a legal obligation, a contractual obligation to tell you, to furnish you with keys to allow them in the property and make the property available to showing during reasonable hours. So you can't put it on the market and the seller say, well, I'm not going to show it for the next 3 weeks. That's not going to be allowed. You'll have to handle it in a way that the MLS gives you as either taking it off the market temporarily or withdrawing the property. C, seller gives the broker, and always in this case, the broker is the listing company, the right to display property on the internet, yes or no. Usually that's yes. To display the property address, that's yes. To allow automated estimates of market value to this listing, check with your broker. I always check yes because it makes all the other CMA modules more accurate. Now, the one at the last, to allow third parties to write comments or reviews about listed properties, put no. Because what this does, there are some third parties that allow you to make a comment about the house. Well, if somebody doesn't like the person selling it, they can go to that and say, you know, your house smells. Pets have run rampant through the house, whatever it may be, whether it's true or not. So you want to mark that as no. It says here, seller acknowledges and understands broker is required to report the condition and terms of the sale to the MLS in accordance with the broker agreement with the MLS. It just says that all the information, the accurate sales price, the accurate concessions, and so forth will be reported to the MLS to help with property values. Marketing the MLS. E. This just says it's going to be put in the MLS. You don't have to understand, but the MLS sends it to thousands of different sites. And I say thousands. I think it is in excess of 1,000, but there's going to be many, many, many sites. Some you know, some you don't. That information goes out, and the seller acknowledges that's going to go out, and people are going to be able to see it. You have 3 ways to have a property marketed in the MLS, and this is what it goes to as far as marketing. Number 1 is active. Active means as soon as you you're going to enter it into the MLS, you hit the button, and when it publishes, it's active. Most of the properties are put in an active right off the bat. The only other 2 ways that you can market a property is coming soon. And the coming soon means it is in the MLS. You have a sign, and you can do that for up to 5 days. You have a sign in the yard. You have it marked coming soon. Nobody can show the property for 5 days. While it is coming soon, you cannot, whether it be you, whether it be the seller, or whether it be another licensee, cannot show the property. If that is found to happen, both licensees will be fined $1,000. It's not anything to play around with. So coming soon means you're pre-marketing the property up to 5 days. You have a sign, it's in the MLS, cannot be shown. Also, if you notice, it says that there is going to be another document that has to be signed. It is talking about a coming soon addendum. That has to be signed as well. The coming soon status is temporary and limited to 5 calendar days. If it is selected, the seller must execute a separate signed addendum regarding the broker's use of it. That is called a coming soon addendum. E3 is the last way that you can market a property in the MLS, and that's called office exclusive. An office exclusive basically means only that office can see the listing. It will not be shown to public websites. You won't see it anywhere in the public. Now, one other thing too, you cannot market to the public. If you have a listing that's office exclusive, you can't put a sign out, you can't put a flyer. This says that the seller acknowledges that only that company will know, and there has to be a separate agreement signed. There's an office exclusive agreement. that has to be signed. The seller has to acknowledge, I'm putting my house in the MLS, but nobody else is going to see it except this company. So again, with the coming soon and the office exclusive, check with your broker, check with your mentor, whoever it is, find out if your property is going to be one of these statuses. All right, so now what we've got here is compensation to the listing broker, and then optional compensation to the buyer broker. This number 7 will say that the seller agrees to pay as the agent of the seller the following compensation not to exceed either a percentage of the gross sales price or a flat fee. Only 2 ways that the buyer broker can be compensated. That amount is put there. Now, the seller has an option to pay or compensate the buyer's broker or the buyer's agent. You'll notice that in bold, it says listing broker compensation, buyer broker compensation are not set by law and governed by any realtor association and are fully negotiable. Your broker will know exactly why that has had to be put into all the documents, but it has pertaining to the settlement that just occurred March 15th. Notice compensation to the buyer broker. If your seller agrees to compensate the agent for the buyer, one of the last 2 is going to be the ways that you will be compensated. First of all, they say the seller says, I'm not going to offer compensation. Mark that box and you move on. The seller will consider paying buyer broker compensation based on the terms and price of an accepted offer. And then the seller has instructed the listing broker for the seller to pay buyer broker compensation as follows. Now, I'm going to try and explain this to you that, well, and I have to, it's not allowing me to go back. Anyway, I apologize for that. What we will do is, if there's no compensation, you mark that first box. The second one, it says they will offer to go case by case. And then the third one says out of that total commission that's being paid to the listing broker, the seller can instructs the listing broker to pay a certain percentage out. That's changed from what it used to be. There is an option. It has always been negotiable, but now it has to be acknowledged that it is negotiable. Okay? Check with your broker on how he wants you to mark that. Generally, he's going to want you to ask who's getting compensated. If the seller's going to be paying compensation, then which one of those bottom 2 boxes to check. Seller acknowledges the offers based on protected class or a violation of state and federal laws, including fair housing, and this agreement is subject to a non-discrimination clause. In other words, if you're going to list a property and they say they do not want to sell to a particular protected class, fold up tent and walk away, because this is a federal law and the penalties for violating this is very severe. Here's where it comes into the optional seller concession. Optional seller concession means the seller can offer to pay some of the settlement charges or costs incurred by the buyer. Now, this is different than the buyer compensation as far as the buyer broker compensation. This is directly towards settlement charges, closing costs, prepaid for the buyer. Now, the buyer can use some of that money to pay their buyer's agent. The seller cannot stipulate how they spend that money. So let's say that you write an offer and it has $15,000 worth of concessions. They're not going to pay a buyer broker. Your buyer can take some of that money and pay the buyer broker fee, and the seller can't stop it. The seller can offer either one of 2 things. They can pay the buyer broker or they can offer seller concession buyer concessions, and the buyers can use this to pay. Go into a little bit more detail on the sales contract, but this is where the seller acknowledges I'm going to give compensation. Agency disclosure. This states that the seller has been recatted. They have been told of the different ways that they can be represented. Lead-based paint. If a house is built prior to 1978, the seller must disclose if they have any reports or information of lead-based hazards on the property. Systems and equipment and appurtenances. This runs in conjunction with the sales contract. These are all the things that are going to convey with the property at the time of contract. If there are items that are going to be excluded, there's a place for the additional provisions, and so you can remember to put that in the listing agreement that the chandelier does not convey, or the master bedroom curtains don't convey, or something like that. Earnest money. This talks about to the seller that any earnest money that is provided in the purchase agreement is going to be held in a trust account, and it will only be dispersed one of three ways. Either when the deal closes, everybody gets credit for it, there has to be mutual agreement between the buyer and the seller, or a court order. But to the seller, when you're explaining this to them at the time of listing, you just tell them the earnest money is being held separate. It's in a trust account. 14 basically says there will be no lawsuits filed. There'll be nothing taken to court because there will not be any trial by jury. You're agreeing to binding arbitration. If there is any kind of dispute, both parties agree to go to arbitration as opposed to suing and going through the court system. Seller's warranty, number 15. Seller specifically represents and warrants that the seller has complete authority to sell property and convey title. So this can be done in a variety of different ways. If it is the seller and they own the property, they can do that. If somebody has power of attorney and they have the ability to sell and sign for that, they also can be an estate, different ways to convey. But whoever is selling, they have to have the ability to sell and convey title. Photographic services. For every listing, you're going to be taking pictures and probably have professionally taken pictures. Seller hereby authorizes broker to have interior and exterior photographs of the property taken, the photographic services, and to have such photographs digitized, reproduced, published, transmitted, and or disseminated and displayed in any form or manner without limitations. Basically, you're spending the money for the pictures, and the seller agrees to have it dispersed to everywhere, though, all the websites, things like that. Be careful if you are working with someone that has a high security clearance, because sometimes they don't want pictures of their home to be on the internet. So I would strongly recommend that if somebody has that you're going to exclude the pictures. You're not going to pay for pictures. You're going to have just one or two pictures, and that's it. Okay, waiver of liability. This says the seller agrees to waive, acquit, forever release, and hold harmless the broker, its office, for any kind of responsibility or liability concerning the pictures. So in other words, they have to give permission for the pictures to be disseminated. Once they are, they can't be, the company and you cannot be held liable for this. Seller may provide some of the pictures there, and this is where if they provide the pictures, they have to provide or validate, or they have to make sure that they own the pictures, that they just didn't borrow them from a photographer who actually owns the rights. Now, here's the additional provisions. This is what I was talking about writing in if something does not convey. If there has to be something to remind you while you're entering these listings, go ahead and put it in the additional provisions right now. Again, it's stressed again, you cannot discriminate on any of the protected classes in fair housing. This agreement is intended to be the legal and binding agreement, or otherwise known as a contract, of all parties, executed on the date. Places for the seller to sign, have an email, telephone numbers, cell phone numbers, and if there's somebody that is selling a property that does not live at the property, get their address. Seller acknowledges receipt of a signed copy of this agreement. Make sure that they initial it and make sure that you leave them one. And again, as anything else, if you have any questions, please feel free to reach out, contact Valley MLS Support at the telephone number that has been displayed, or email them at mlssupport@valleymls.com. Thank you and good luck.